unpacking Maryland disclosure law, what sellers must say and what buyers can expect, and those spicy, do I have to tell them about the ghost or crime questions that always blow up forums. Quick disclaimer, I'm not your lawyer. This is general info for Maryland residential sales, so try not to cook me on a case-by-case basis. All right, here we go. In Maryland, every seller of a single-family residential property chooses one of two paths when you work with a broker. You either disclose or you disclaim. Even if you sell as is on a disclaimer form, you still have to reveal any latent defects that you actually know about. These are issues that a buyer would not see or be able to catch on careful visual inspection that pose a direct threat to health or safety. That's the heart of the law. So that's rule number one. If the disclosure disclaimer form isn't given before the contract is signed, the buyer gets an unconditional right to rescind anytime before they receive it or within a 5-day period after getting it. Does that make sense? So if you're a buyer, use that window. If you're a seller, don't miss that deadline. Be smart and sign your documents in advance. Anyway, all right, water cooler topic. This is a fun one. Ghosts, haunts, and crimes. Boom, boom, boom. Do you have to disclose a murder, a suicide, an accidental or natural death, a felony, or someone that had HIV or AIDS in the home? Oh my gosh! In Maryland, no, you actually don't. Those are not considered material facts or latent defects under state law. So owners and agents are immune from any liability for not disclosing them. Caveat, if you are asked directly, you cannot mislead. So the statute says that while these are not required disclosures, you cannot misrepresent. So if a place is haunted or somebody has died in there and you have knowledge of it and somebody asks you, you have to tell the truth. That's the way it is. So now can you cancel a deal because of that? No. Sorry. Maryland's real estate ethics rules require protecting the public against fraud and misrepresentation. So keep your answers accurate and your advertising clean. Very simple. Every county, with the exception of Montgomery County, does not require radon testing. Montgomery County has its own rule. So for those that aren't as familiar with Maryland or Montgomery County, that's your Bethesda, Chevy Chase area, Potomac. It's a very wealthy suburb of DC. All single families, detached or townhomes, must have a radon test within 1 year before settlement. Buyer and seller must get the result, and there are limited exceptions, but practically speaking, you can expect a radon test in Montgomery County. On other properties throughout the rest of the state, it is not a required thing unless your lender requires it, which would be on a case-by-case basis. Okay, moving on. Next topic. On properties with a private well, the contract must require well water quality testing as a condition of the sale. Settlement cannot occur until both sides have received and reviewed the lab results. Results are valid for 3 years, and the buyer can waive that testing in writing if they so choose. Usually not recommended, but on a case-by-case basis, that can be the right way to move forward on a transaction. Quick hitters. If I check as is, I don't have to disclose anything? No. False. We have to tell buyers if someone died in the... False. My HOA or condo packet is really just busy work. False. Hi, guys. So what is a classic latent defect? You know, it could be a failing retaining wall that's behind a hedge. It could be a chronically wet basement with hidden mold. That's a fairly common one. An unsafe deck leisure that is concealed by other finishes. Just things that are health and safety hazards that are not obvious. That is what a latent defect is. All right. Question. Okay. Haunted houses. Believe it or not, Maryland has a few. However, there is no special ghost law here. Paranormal reputation falls under a psychological impact, kind of like death and crimes, where you're not required to disclose it. Best practice, if somebody asks you, don't opine about it. Just refer buyers to their own research sources. and public records, that's the way that you're supposed to respond back to it. So for my agent friends, because every now and again we still have this question pop up, even amongst agents. Buyer asked me if the house is haunted. What do I say? Well, state law actually doesn't require disclosure of psychological impacts as your agent. I'm not going to speculate. So here are some resources to research: neighborhood history, sex offenders nearby. That's a juicy one. So the contract in Maryland actually points buyers to the Maryland Sex Offender Registry website. Buyers themselves are actually responsible for checking to see if the address that they are moving to is, near anybody. It's on that list. Okay, let's talk floods, drainage, and climate realities. So if the home is within 1 mile of an EPA Superfund site, the seller has to attach a state-mandated addendum with the site's info, and the buyer automatically gets a 5-day right to void the contract and a full deposit refund. Put simply, buyers get a cooling-off period for this. For those that aren't familiar with, what an EPA Superfund site is, it basically identifies the most serious hazardous waste sites in the U.S. That are eligible for long-term cleanup, and then it starts to do that permanent cleanup process. Let's see. Flood talk. Maryland State Form asks whether water stands on the property for more than 24 hours after a heavy rain and whether that property is in a flood zone. It doesn't require disclosure of prior flood losses. So buyers, when you are looking at waterfront property or water access property, which obviously in this area we have a lot of, you want to pull FEMA maps. FEMA's got a pretty easy to use website. Plug in the address. It will take you right there and show you exactly what that property history has been. We can also, as agents, ask the other side for utility information where you could see water. We can ask for, you can see water bills, which will give you an idea on whether, are these people on crack or do they have a crack in the main line? You never know. So just asking for more information, even though it can seem like an annoyance, these are usually very big purchases. It's probably good to have as much data as you can get. And even properties that are not in a flood zone or in an area where you would think there would be a flood, it is good to understand if there's moisture issues, because that can lead to, again, health and safety concerns down the line. Condo and HOA resales. Condos. The seller's got to deliver the resale package no later than 15 days before closing. After the buyer receives everything, they get a 7-day, 7 calendar days, not business days, calendar days to cancel for any reason. Don't play calendar chicken with this, okay? Track the dates on every contract. If there is an HOA or a condo involved, particularly a condo, seller's got to order those condo docs immediately, because you don't want to risk losing the buyer early on or later in the stage because you sidetracked and forgot to give them the condo docs. It's important for people that are buying to be able to know exactly what they're buying into, what's planned for the future, what it's been, because that's where they're going to live, especially in a condo. It's important for that. HOAs on resales. The required HOA disclosure can come at or before a contract or within 20 days after contract. But if the buyer didn't get it 5 days or more before signing, then they have 5 days after receipt to cancel. Again, dates matter. So same thing. So HOA is 5 calendar days. Condo is 7. Lead paint. Now I got to say, lead paint, not as prevalent as you would think for, this area, which has a lot of colonial history. I would say the bulk of our inventory is probably built in the 60s and 70s. Certainly our share is in 2000s construction, but pre-1978 housing. Federal law still requires lead-based paint disclosures, which gives buyers a 10-day opportunity to conduct a risk assessment where they can go in and see if the place has lead in it. And then if it does, what are my options? So even if you forego that in Maryland, you still have the state. Quick hitters. Let's do septic. Maryland has now change how they license their septic inspector. So they are now licensed through the Department of the Environment, through the state. So if you're ordering an inspection, confirm that the inspector is licensed there. And then wholesalers, we do deal with some investors sometimes. So wholesalers effective in Maryland as of like 2 weeks ago, any contracts that you guys are assigned or you're assigning requires a specific written disclosure now, just to protect the prospective assignee. So if that notice isn't given, then the owner or the assignee can rescind before closing without any penalty. So it's just something, again, stay on top of the updates, stay on top of the paperwork to make sure that you're able to get paid, my friend. All right. Well, sellers, when in doubt, disclose and let it out. The truth shall set you free. I don't know if that's how it goes, but that's, when you have an idea, sellers, give the disclosure disclaimer early on. You get that done at the time of listing. Almost all people do. Continue that process. It's for a reason. List any known latent defects that even if it's questionable to you, you would rather overshare than undershare and have it bite your ass later. Watch the Superfund and the MoCo radon rules. And if you're on well and septic, line up testing and license pros, buyers, track your rescission windows. We do that for all of our buyers and frankly, for all of our sellers. We deadlines within each contract that we have to make sure people are meeting. And if they're not, then we want to know what the motivation is. Are they still motivated to sell? Are they still motivated to settle? Or have the motivations changed during the contract period, either through one party, another, or an ulterior force? So read the condo rules, read the HOA rules, verify flood and lead risks, and by all means, do final walkthroughs on all these properties prior to settling on them. They're valuable. A lot of people take them for granted, but just make sure that what you're buying is exactly what you're expecting to get. So that wraps it up for this week's open floor. That's Maryland disclosure law in one page, baby. Drop your scenarios in the comments, and we'll see you on the next open floor. Thanks, y'all.